Hey y'all, it's the loud little ducky. Today we are going to go over the Rule 26 backstory in the Owens v. Echard. This one is dedicated to Gingras because he thinks, so what if this is the backstory? Who cares? Well, I think the courts care. But let's analyze this from the textbook definitions all the way to what actually had happened. So, stick around and let's jump in. First, let's go over the Arizona Rules Family Law Procedure, Rule 26. Section C. Sanctions. Number 1. Generally, if a pleading, motion, or other document is signed in violation of this rule, the court on motion or on its own may impose on the person who signed it, a represented party, or both, an appropriate sanction, which may include an order to pay to the other party or parties the amount of the reasonable expenses incurred because of the filing of the document, including a reasonable attorney fee. 2. Consultation. Before filing a motion for sanctions under this rule, the moving party must A. Attempt to resolve the matter by good faith consultation as provided in Rule 9C, which we will get to in just a moment. And B. If the matter is not satisfactorily resolved by consultation, provide the opposing party with written notice of specific conduct that allegedly violates Section B. If the opposing party does not withdraw or appropriately correct the alleged violations within 10 days after the written notice is served, the moving party may file a motion under Subpart C3. Number 3. Motion for sanctions. A motion for sanctions under this rule must A. Be made separately from any other motion. B. Describe the specific conduct that allegedly violates Section B. C. Be accompanied by a Rule 9C good faith consultation certificate. And D. Attach a copy of written notice provided to the opposing party under Subpart C2B. So those are the layout for Rule 26. Most of us know these by heart already, but that is the textbook definition. Rule 9 of the Arizona Family Law Procedures, duties of parties or counsel. A current address. Parties or counsel must keep the court informed of a current mailing address, email, and telephone number. B. Responsibility to the court. Parties and counsel are responsible for knowing the status of their case and keeping the court informed of material changes in the status of their cases. C. Good faith consultation certificate. Number 1. Generally, when these rules require a good faith consultation certificate, the certificate must demonstrate that a party has made a good faith attempt to resolve the issue. The consultation or attempted consultation required by this rule must be in person or by telephone and not merely by letter or email. Number 2, and this I found to be interesting, domestic violence. The parties are not required to personally meet or contact each other if A. There is a current court order prohibiting contact between the parties, a history of domestic violence between the parties, or an allegation of domestic violence. And B. The alleged victim of domestic violence is self-represented. So while we have an order of protection that is due to a so-called relationship, have having an intimate relationship or just a regular relationship, it's not a restraining order necessarily, but it is an order of protection, order of harassment. So question in this is that a reason why there might not have been a good faith consultation certificate in this thing? Can that be a reason? Because when this went out, she was self-represented and they had order of protections against each other. So let's take a look at the timeline. So on October 24th of 2023, Clayton Echard gets an order of protection against Laura Owens. The next day, 10/25/23, Laura gets an order of protection against Clayton Echard. So both have mutual OOPs, or orders of harassment, against each other, which means, don't contact each other, don't harass each other, things like that, right? So, because at that point, these two they did not have attorneys. Clayton got one at one point, Deandra. They can't contact each other in regards to things because they're like, hey, don't contact me. The court says don't contact them. But then we have on December 12th, 2023, Clayton obtains Woodnick Law. And then we have a little bit later, in December 28th, 2023, Owens obtains Alexis Linval. That's one of her first attorneys on this case. So now they have attorneys. But here is the thing. We are going to go over one of the first filings in this case from Woodnick Law. And it was filed on December 12th, 2023. Pretty much the first day that he came on, because he also filed his notice of appearance as well on this day. And I want everything on this particular thing from Owen's point of view and Echard's point of view, all in one nice location, wrapped up in a bow, so that we have both sides of the story in this. In the Superior Court of the State of Arizona, in and for the County of Maricopa, in the matter of Owens v. Clayton, amended response to petitioner to establish paternity. This is assigned to the Honorable Judge Julie Mata. Respondent Clayton Echard, by and through undersigned counsel, hereby submits the amended response to petition to establish paternity, legal decision-making, parenting time, and child support, and states the following. Number 1, background. 1. Petitioner has not provided any verifiable scientific evidence that she is pregnant, and all DNA tests have come back showing little to no fetal DNA. The testing company Ravgen Incorporated has indicated that it will not release records of the testing without a court order. So somebody needs to order Ravgen to hand over the results, because they are not doing so, or the records, not the results, because the parties have the results. Number 2, petitioner filed her petition only after respondent indicated that he did not want to have any relationship with her, romantic or otherwise, after she performed oral on him on May 20th, 2023. Prior to her filing, petitioner repeatedly threatened to go to the media about her pregnancy and sent respondent over 500 iMessages from different phone numbers and email addresses. Judge Galakakis, or Judge G as we call her because I mess it up, found these messages and petitioner's conduct to constitute harassment when she granted respondents injunction against harassment. So not an OOP, an injunction against harassment. And she signed that on November 2nd, 2023, even though the hearings were done in two different ones, on the 24th and the 2nd. And he's attached that as an exhibit. 4. A sampling of petitioner's efforts to force respondent into a relationship are documented in part below. A. Petitioner drafted a contract for respondent to sign that promised for a period of 1 week while determining the best of action for their pregnancy. Party A and Party B will exclusively explore a relationship with intention. There is no obligation to engage in intercourse if either party is uncomfortable with the act. Exhibit 2 and Exhibit 1. B. June 28, 2023. I have offered to give you control over the outcome of the pregnancy if we date exclusively and care for one another. That's not how any of this goes. Not how it goes. He gets a say. Now, the woman doesn't have to follow it, but he can have an opinion on the outcome, whether he dates you or not. And a woman can choose to disregard or take into consideration what the other person thinks, because the baby is in her body, so technically she has control over what happens, whether the guy agrees or disagrees, which that is a whole nother discussion we are not getting into. I need to know your decision tonight because I'm getting rid of abortion pills. Is it a no, or if I don't hear back from you tonight? Which is a song that you can find on Megan Fox's channel. C. Petitioner threatened to post on her public Instagram account that she was pregnant with respondent's children, now it's plural, if he did not unblock her, and said, if I can't get you to do it, then maybe the public can convince you to. Right here, threats. Do what I say or else. D. Petitioner contacted respondent's father, ostensibly to convince him to force his son, respondent, to speak with her. I have not heard back from Clayton and presume he has still blocked me. 5. While this family case was pending, petitioner posted an anonymous blog post on medium.com, which she later deleted. So this anonymous blog post was deleted, but we have it, I think. Contacted the news media and made multiple pleadings on reddit.com, claiming that she was pregnant with respondent's children and including a Dropbox of doctored medical documents. Yes, we do have that post. I believe that's the anonymous woman post. I didn't know it came from Medium. 6. Despite 2 fetal DNA tests indicating little to no fetal DNA and 1 test lost in transit, petitioner posted another Medium article identifying herself as the anonymous woman. Okay, so that was on Medium. That's where that came from. I didn't know if she posted that on Reddit or what. On December 8, 2023. In the article, petitioner continues to maintain she is pregnant with twins by respondent. Subsection 2. Response to petitioner's petition to establish. Respondent affirmatively alleges that the petitioner is fabricating pregnancy as well as refusing a paternity test. So Clayton says that he is saying that she is fabricating this and he is not refusing a paternity test because he's already done 3 apparently. Respondent affirmatively alleges that neither pregnancy nor paternity has been proven. Yep. And none of those have been proven to this day. Respondent contests that petitioner is pregnant by him and therefore venue is not relevant. Respondent contests the petitioner is pregnant by him, and since petitioner is unwilling to participate in a fourth paternity test, so the petitioner does not want to do a fourth one. Why does she not want to take a fourth test? Paternity and jurisdiction for determining validity are unable to be proven or determined. Respondent contests petitioner is pregnant by him and affirmatively alleges that petitioner has neither proven pregnancy nor respondent's paternity. 12. Respondent contests the petitioner is pregnant by him and therefore there is no legal parenthood to establish. Respondent alleges that only oral was performed between the parties. Respondent further alleges that despite multiple requests to do so, petitioner has refused to take a paternity test. Petitioner responded to respondent's request via email stating that she would only take a paternity test if the parties were to date exclusively. And then exhibit, which I guess is the dating contract. Petitioner has threatened that she will write defamatory comments about this matter and release it to the press. Petitioner has not established proof of paternity. Upon information and belief, petitioner suffers from mental health issues and has caused respondent to become concerned that she is stalking him. I think that is a valid concern. Petitioner was not married at the time the minor child or children were born or conceived, or at least 10 months before minor child or children were born or conceived. Yeah, because they didn't date. Or they weren't married either. Respondent contests the petitioner is pregnant by him and therefore legal decision making and parenting time are not relevant. Obviously, if there's no babies, we don't need to discuss legal decision making for children, and we do not need to discuss parenting time or custody between the imaginary children. Respondent does not have any information regarding any court action in this state involving the minor child or children in question that could affect this case, including court cases for enforcement and relating to domestic violence, protective orders, termination of parental rights, and adoption. Respondent does not know a person other than petitioner who has does not know someone with physical custody or claims legal decision making, legal custody, or parenting time rights to any of the minor children in question. 17. Respondent contests the petitioner is pregnant by him and therefore unreimbursed medical expenses increased by petitioner are not relevant. Respondent contests that the petitioner is pregnant by him and therefore unreimbursed other expenses are not relevant. Right. Like he does not need to pay your medical bills because you were never pregnant. He's not paying for your Banner Health patient portal. He's not paying for your Planned Parenthood visits to all of them in California that you have said you've gone to but haven't. And I'm sure she has been to some, just not in this case. Clayton does not owe any money for medical-related expenses to her trying to prove this case. Respondent contests the petitioner is pregnant by him and therefore the parent information program is not relevant. Respondent affirmatively alleges that domestic violence has not occurred in this relationship. So there's the line. Well, it says domestic violence has not occurred in this case. And that can mean that in this case, it means that it didn't happen. But in other cases, somebody could just be saying, no, there was no domestic violence. So because it was not a domestic violence restraining order, and it was only an injunction against harassment and an order of protection, does that part about needing a good faith consultation certificate go away? Because is it only domestic violence, like restraining orders, or is it any like orders of protection and stuff of no contact? Make it to where you can't or don't have to put that up because there's a reason for it not being there. That is a question I would have for lawyers because I am not one. But I thought it was an interesting thing to point out. "21. Respondent affirmatively alleges that to his knowledge, neither party has been convicted for a drug offense or driving under the influence of drugs or alcohol in the last 12 months. 22. Respondent contests the petitioner is pregnant by him and therefore child support orders for either party are not relevant. Correct. Respondent denies allegations not specifically admitted herein. Respondent is entitled to an adjudication of non-paternity. Petitioner's relentless and harassing behavior through the media will only continue if this matter is not resolved by this court, and even when it was resolved, it still continued. Finding respondent is not the father of any alleged and believed to be fictitious children. Rule 26 sanctions are appropriate. So here is our first mention of Rule 26. Petitioner has violated Rule 26B, Arizona Rules of Family Law Procedure, and sanctions under Rule 26 are appropriate. Petitioner filed this action for the purposes of harassing respondent and forcing him to communicate with her. Despite respondent's repeated requests, petitioner has provided respondent with no verified scientific evidence proving she is or was pregnant. Further, after filing the petitions, petitioner filed a motion to communicate, threatening to take her pregnancy to the media if respondent did not communicate with her. The motion was denied. See petitioner's motion to communicate, filed August 8, 2023. Petitioner also filed motion for contempt, which this court also denied, which requested this court hold respondent in contempt for not communicating with her. See petitioner's motion for contempt filed August 23, 2023, also denied by this court. As such, petitioner's petition lacks evidentiary support, is being presented for the improper purpose to harass respondent into communicating with her and to cause respondent to incur fees. The requirement of Rule 9C, which we went over as well, have been met so far as there has been excessive communication regarding the issue, not limited to the petitioner's recent Medium article and 500 plus texts and emails that predicate Judge G's granting of the injunction against harassment. So there's proof that they have tried to communicate this issue. He did communicate about this issue, and it wasn't good enough for Owens, so she filed this lawsuit. So there was a good faith basis to try to resolve this without it needing to go this far. Whether they attached the certificate or not, that has been done. But does that void everything because one is not attached to this motion? Because it isn't attached to this particular motion. 27. Respondent is entitled to his reasonable attorney's fees and costs incurred based on petitioner's unreasonable pursuant to ARS 25-324. This 25-324 is where Owens lost as far as financially. This is where Clayton won his attorney's fees, was based on ARS 25324. So when Gingras says without Rule 26, there was nothing else up for debate and to be decided on, that is a lie, because we had 25324, even if taking 26 off the table. Petitioner initiated this filing based on pregnancy that could not have occurred from oral. Despite the petitioner repeatedly harassing respondent, filed numerous bad faith pleadings with this court in an effort to force respondent to communicate with her, went to the media when the respondent would not unblock her, and fabricated medical documents. Petitioner behavior is the very definition of unreasonableness, and I could not agree more with Woodnick on this. Wherefore, based on all the foregoing, respondent respectfully requests the court enter the following orders. A. Issue an order declaring that respondent is not the natural father of the minor children or any children born to the petitioner. B. Order that both parties be ordered to submit to such blood and tissue tests as may be necessary by the court to establish paternity, and petitioner be ordered to pay all costs and expenses of the lawsuit under Arizona rules of 25809. So this is another rule. So we have 25809 and 25324 without Rule 26. So still two other things that need to be determined, along with, is Clayton the father, without Rule 26 on the table. Wasn't like, oh, Rule 26 comes off the table and there's nothing else to determine. Because there is in Woodnick's first official motion he filed. C. Issue an order compelling Ravgen Incorporated produce all records and documents related to the fetal DNA test in this matter. D. That this court sanction petitioner pursuant to Rule 26. E. That this court award respondent his reasonable attorney fees and costs based on petitioner's unreasonableness pursuant to ARS 25324. So he was not asking for attorney's fees based on Rule 26. He was asking for that to be a sanction. He was asking for attorney's fees, which is the only thing that was awarded in this case, under ARS 25324, which I'm sure everybody knows by now if you have been listening to this case or watching it. Like I said, I just want everything laid out and wrapped up with a nice little bow. Enter appropriate orders regarding costs and attorney's fees herein, and G, for other and further relief as the court deems just and proper under these circumstances. So he's asking for all of those things, but he's saying, I'm also asking for further relief that the court deems basically necessary. So if the court finds something else that the court wants to do to give further relief to Echard, they're asking the court to do that. Respectfully submitted this 12th day of December 2023, Woodnick Law. And it was signed and e-filed and sent to the right people. Okay, so that is the first motion where Rule 26 sanctions was brought up. Okay, December 12th, 2023. All right. 16 days later, which is more than the 10-day safe harbor period. Now, if we remember the rules of Rule 26, it states that it needs to be filed in a separate motion. It was not, it was just included in another one. So if we go by that, that has not been done yet. So we have to look at this point, has Woodnick done it according to the rules? And at this point, I would say no. Because there was not a good faith consultation certificate. I agree, that was not filed as of now. One will come later. Two, it wasn't in a separate motion at this point. So as of December 28th, 2023, there's not a separate motion for Rule 26 sanctions, and there has not been a good faith consultation certificate created. But the party has been notified and does the order of protection and injunction against harassment prior to now both of them having an attorney, because when he said Rule 26 sanctions, she was not represented yet until the 16-day later period. Is that why there's no good faith certificate? Because of those orders of protections. So we're going to be fair and straight across the board. All right. As we go through this timeline, things will change. But at this point, I don't think Woodnick has done it properly, in my opinion. Does that mean Gingras is right about everything? No. And we'll get to why not. But let's read this. 12/28/2023, Alexis Linvall, attorney for Owens, because she did file notice of appearance as well on this day, filed petitioner's motion to establish paternity, legal decision-making, parenting time, and child support with prejudice. Now, I'm not going to go over the whole thing. I'm going to go over the snippet about Rule 26. So, Gingras was not this, oh my God, no other attorney found this and argued this to try to get the case dismissed. Because Alexis Linvall did. So we're going to give her credit, because Gingras didn't come in here and find something that no attorney did because they were stupid and he's the best lawyer ever. That's not how any of this happened. Linvall did find it, and she did argue it. It was also denied, which when the new attorney comes on and argues the same thing, if the judge denied it by a different attorney, why wouldn't she also deny it by a future attorney? It was already argued about and denied. She's not going to listen to another argument about the same thing. She's just going to deny it. She does not need to hear oral arguments because we've already been over this subject, but it was before your time. I get it. So it says B, respondent's only potential viable claim is for attorney's fees, which he did not personally incur. Let's hear her out. On December 12th, respondent filed a motion for leave amend his response. The proposed amended response requests the following relief: an order of non-paternity, an order compelling Rabgen, a non-party, to produce fetal DNA records, 3, Rule 26 sanctions against petitioner, and 4, attorney's fees from petitioner, which is 25/3/24. Items 1 and 2 are now moot. So she's saying the order of non-paternity is moot, and an order to compel Rabgen for the fetal DNA records is moot. Why? Because petitioner is now not pregnant. So this is the first time we find out that Owens is no longer pregnant. Is December 28th, 2023. But she went to MomDoc and found out about this at the very end of October. So here we are almost 2 months, and she's just now doing this, just now telling people. And he's incurred no costs before this time period because he's already hired Woodnick for 16 days. Item 2, the request for relief of the response is not appropriate place to request a court order discovery from a non-party. As to item 3, which is the Rule 26, respondent failed to comply with any of Rule 26 prerequisite requirements. Specifically, respondent did not attempt to resolve the matter by good faith consultation as provided by Rule 9C. They did, before all this was filed, and 500 plus texts and emails, Clayton did try to resolve this with Owens. From the lawsuit on, or from the order of protection and injunction at the end of October, no, there has not been any communication because of those orders of protection. But prior to the end of October, Clayton made a good faith to try to resolve this matter. So I think that one's canceled out. There was an effort made. We don't necessarily have a certificate for it that states that, but it has been made. As the Arizona Rules Family Law Procedure 26C2A. Even if he had tried to resolve this dispute, respondent did not provide the opposing party with written notice of the specific conduct that allegedly violates Section B. I believe in that last motion we read, he said, she is not pregnant. We only had oral. They are not my babies. And all this stuff. He laid out what things were not true. And her claiming those things that were not true, those are the alleged violations that she is committing in this. So violates Section B, Arizona Rules of Family Law Procedure 26C2B. We read that. Okay. Additionally, sanctions cannot be requested as part of a response or of any other pleading for that matter. Pursuant to Rule 26C3A, a motion for sanctions must be made separate from any other motion. Respondent failed to attach a Rule 9C good faith consultation certificate and or attach a copy of a written notice provided to the opposing party under subpart C2B, Arizona Rules of Family Law Procedure 9C3. So here's where I'm going to agree. He did not make it a separate motion. Attached a copy of the written notice, and that was not attached either. And the good faith consultation certificate was not attached as of right now, as of 12/28. Okay? So Alexis Linville is correct in stating these things were not followed as per Rule 26 and 9C. Okay, don't hate me just because I'm saying Owens attorneys are correct in this part as of right now. Okay, we will get to the other part. Something else that Alexis Linville, attorney for Owens, filed on December 28, 2023 was petitioner's response to expedited motion to extend dismissal date on inactive calendar and schedule an evidentiary hearing. That is a long title for a motion. So, we're going to start at the top of this page. Even though it's in the middle of a sentence, we're just going to read through the parts that we have here because the first paragraph is just attached to something else, but it's the second paragraph that matters to me in this. But it says impregnated petitioner and has stated he wants nothing to do with her. So he's saying, Clayton impregnated Owens is what she's saying. And has stated he wants nothing to do with her. Yeah, he wants nothing to do with her, and the court told him in October he doesn't really have to have anything to do with her. We're going to decide this case, but you don't have to deal with her anymore. And is seeking to ensure this case is not dismissed long before the dismissal deadline. But in any event, one unavoidable fact remains. Petitioner acknowledges that she is no longer pregnant with respondent's child, meaning there is no paternity to establish. There is nothing left for this court to adjudicate, and this case should be dismissed. Well, that's the thing. That was only one of the things that Clayton was seeking, was for non-paternity, Rule 26, and attorney's fees, 25-324. So just because we take the non-paternity off and the Rule 26, there is still attorney fees to be discussed. Third, given petitioner's acknowledgement that she is no longer pregnant, the only remaining issue is respondent's request for attorney's fees. Attorney's fees that upon information and belief he did not personally incur. All right, let's discuss. Respondent requested for Rule 26 sanctions against petitioner, which is not viable, as respondent did not satisfy the Rule 26 prerequisite requirements. For instance, respondent has attempted to shoehorn his request for sanctions into a proposed amended response and his motion to extend, even though Rule 26 clearly states a motion for sanctions to be made separate from any other motion. After a good faith consultation, which she says has not occurred, but it has occurred prior to this filing. Arizona Rules Family Law Procedure 26C3A. Wherefore, petitioner asks this court to deny respondent's motion to extend. Petitioner is not now pregnant. This is no longer a paternity establishment case, as there is no paternity to establish. This case is now moot, and for this reason, petitioner seeks to voluntarily dismiss this case. Petitioner has concurrently filed a motion to dismiss her case in full, and this court should grant the motion and deny respondent's request for an unnecessary hearing. So she's saying we need to take these things off, and then the attorney fees that is left to discuss, she does not think that he needs to be compensated for attorney's fees at this point because he has not personally incurred any attorney's fees. The thing with the attorney's fees is there was money raised right after the first injunction against harassment where Clayton was pro se. There was like $8,000 raised. And I think that went to Deandra. And then he hires Woodnick. And Woodnick is hired for at least 16 days. And you have to think about the hiring cost and then, the meet and confers, the motions and emails and everything he's done within 16 days of this case. But Owen's attorney is saying he did not personally incur these fees. And I don't know if she means that because there was $8,000 raised, which a retainer fee for an attorney cost usually way more than $8,000 alone, that he should not be awarded these fees. But even if somebody raises funds for a lawsuit, that does not mean that they cannot get those funds sent to them. Like, they can still win attorney's fees just because somebody else raised the money. Because maybe with those attorney's fees, he could pay those people back. if he wanted to, if there was money for that. But the fact is that he did incur attorney's fees. Even if it was just for 16 days, he did incur them. And there was more stuff prior to this from August 1st till now. He still had to file motions and things like that. That stuff is not free. A motion is not free to file. It may not cost a whole lot, but it's not free to file. So he should be awarded those fees. Moving on. So we have 29th, 30th, 31st, 1st, 2nd, 3rd. So 7 days or 6 days later, after Alexis Linvall, Owens' attorney at the time, filed, hey, you didn't do Rule 26 sanctions correctly, Greg Woodnick, attorney for Clayton, filed a motions for sanctions pursuant to Rule 26, standing alone. So at this point, Woodnick has now filed a motion that is separate from any other motion. She has been informed. And we have a good faith consultation certificate. So the good faith consultation certificate says, in conformance with Rule 9C, Arizona Rules of Family Law Procedure, counsel undersigned hereby certifies that counsel Clayton Echard satisfied his Rule 9C obligation when he attempted to meet and confer with petitioner on August 16th, 2023 at 1:48 p.m. and 2:50 p.m. text messages below, as well as in all of his subsequent filings and communications to petitioner that indicated he could not be the father of her alleged twin fetuses, including but not limited to respondent's injunction against harassment proceeding against petitioner on October 24, 2023 and November 2nd, 2023. See also respondent's motion for leave to amend respondent's response to petition to establish paternity. Respondent's response/objection to petitioner's motion to dismiss petition to establish paternity, legal decision making, parenting time, and child support with prejudice. Additionally, undersigned met and conferred with petitioner's counsel, Alexis Linvall, who already has filed to withdraw from representing the petitioner over the phone on December 27, 2023. So 6 days into this case now, Alexis Linvall comes on December 28th. By January 3rd, Alexis Linvall has withdrawn from this case. 6 days for her to withdraw from this case. Now, he filed all this after they were like, you didn't conform with the rules. And she's already seeking to dismiss it. And then Woodnick files the Rule 26 sanctions to dismiss it. Or the Rule 26 sanctions after Owens is like, I want to dismiss this case. So, should this stand? Well, the thing is, it doesn't matter anymore whether he did this correctly or not. That he filed this on January and did it correctly in January after Owens wanted to dismiss voluntarily. Because Gingers came in and was like, hey, you didn't do this correctly. You didn't file the stuff until after she already wanted to dismiss it. And then Woodnick, on April 3rd, 2024, motion to withdraw was filed and approved by the judge on May 16, 2024. So now it doesn't matter whether he did this correctly or he didn't do this correctly because he's withdrawn this whole thing. He's like, all right, we're just going to get rid of Rule 26, but we still have Rule 25 through 24 to get our attorney's fees. And we can still go for non-paternity. So there's still some things to be discussed. Even if we take non-paternity off the table, we still have Rule 25 through 24 for attorney's fees to discuss about this case, and if there should be any other sanctions that the court deems necessary in this. And so the thing is Owens was never sanctioned in this case. Rewarding attorney's fees and costs, you can consider it a sanction, but it's not necessarily a sanction. Like, it's not labeled as a sanction. It's just considered, you did this, and we're awarding fees and costs. Usually the person who wins the suit gets awarded the attorney's fees and costs. That's usually just how it goes. It's not her being sanctioned on behalf of her behavior. She didn't get sanctioned for her behavior. She has to pay fees and costs, I guess, because of her behavior, but it's not technically labeled a sanction. It can be considered one, but it's just not one. She could have been sanctioned for other reasons for her behavior, and she could have had to pay attorney's fees and costs, but none of that happened. The judge did not pile on, which she could have done, but yet she's biased. If she was biased, she could have sanctioned her and awarded attorney's fees and costs. She did not. She just awarded attorney's fees. So the point about Rule 26 is moot because it no longer exists. Here is the good faith consultation to try to meet and confer. So Wednesday, August 16th, it says, it's blank. Please check your email. Ravgen closes soon. I want to do the test. I need you to respond, though. You want to do the test with no stipulations? Owen says, you're going to be forced by the court to meet up with me, Clayton. You might as well go along with the stipulations since it means 100% I'm doing the test. Clayton says, so if we meet up once in a very public setting, like a coffee shop, you will then take the test afterwards. Owen says, you're going to be required to do that regardless of whether I take the paternity test now or in February. No, it is with the week's worth of stipulations and hopefully more, but absolutely no requirement in order for me to take it earlier. Again, it's all for you. I know who the dad is, you. So I'm doing you a favor here by offering to do it early. I have been so effing patient with you, Clayton, when I shouldn't have been. I never wanted blah, blah, blah. And then we have, I think the app gave me a new number, but it's blank. If you will meet up with me, I will withdraw my request for sanctions. Well, you didn't get your sanctions, so it didn't matter. I also don't want to cancel my appointment because you need to be held accountable. Clayton says, so you will meet up in the court with a mediator present? Owen says, that's not how it goes. The whole point of a consultation is not to waste the court's time if the issue can be resolved outside of the court, which this can. So we can meet up, just us, and then I will withdraw the request for sanctions. He says, would you meet up in a public location, like a coffee shop? You want to talk in public about this? He says yes, in a setting where people and security cameras are, just so that we are both protected in the event that one of us were to try and make up a story about something that happened. So this is him saying, hey, I am willing to meet up with you to resolve this. She doesn't want to do it in public. She wants it to just be them two. She wants stipulations. But he is saying, I will meet up with you. I will meet up with you in public. I will meet up with you if it's in a mediation. I will do these things to try to handle this. She doesn't want to. She doesn't need anybody present that can fact check her. She needs to be able to spin her narrative, and she can't do that if they're not alone and if they're in public. So this is his attempt to try to meet and confer with her, his good faith effort. So it was done. There just originally wasn't a certificate attached, and then later there was one done. But it doesn't matter because that stuff is taken off the table. So that is I would say, unbiased, because I was fair in calling balls and strikes, even though I still land it doesn't matter. And I'm going to say, so what that he did not do it correctly, because Rule 26 was not on the table to be discussed. And you spent most of your appellate brief discussing Rule 26 when it wasn't even a deciding factor, because attorney's fees and costs were based on 25,324. All right. Something we have not done in a bit, but in true loud little ducky fashion, our quote of the day. And I want Owens and everybody else to remember this. You and Gingras, you reap what you sow. If you plant dishonesty, you will reap distrust. If you plant selfishness, you will reap loneliness. If you plant pride, you will reap destruction. If you plant envy, you will reap trouble. Laziness, you will reap stagnation. Bitterness, you will reap isolation. Greed, loss. Gossip, reap enemies. Plant worries, wrinkles. Sin, you will reap guilt. But if you plant honesty, you reap trust. Planting goodness reaps friends. Humility, greatness. Perseverance reaps victory. Consideration, harmony. Hard work equals success. Forgiveness, you reap reconciliation. Openness, intimacy. Patience, improvements. Faith, miracles. So just a friendly reminder that you reap what you sow. Karma is a bitch. If you like this video, please give it a thumbs up, share it, subscribe if you haven't, and turn those notification bells on. And we will be back very soon with the reading of the response to the appeal by Woodnick. Bye.